wants to talk about trademarks? I do. It's trademark time. Who's ready to talk about trademarks? Trademarks, it's the trademark song. All right, so a few weeks ago, I made a video kind of talking about the general process and steps involved in getting a registered trademark with the United States Patent and Trademark Office. Then a few weeks later, I made another video talking specifically about trademarks for standard character marks or word marks. And now I'm going to make another one specifically about logos or design marks. And it's going to be fun, you guys. I'm telling you now, it's gonna be a blast. Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. You're watching All Up in Your Business, and today we're gonna talk about how to get a trademark registration for a logo or a design mark. If this is your first time at All Up in Your Business, welcome. Please be sure to subscribe and click that little bell so you get notified anytime I post a new video. You can also check the description for additional information and resources, including a link to download my free Brandish DIY trademark guide, where you'll learn even more about trademarks. And a quick little legal disclaimer: while I am a lawyer, I am not your lawyer. The stuff that I talk about in all of my videos should not be taken as a substitute for actual legal advice. If you need help with a legal issue, you should consult with a lawyer, and don't just rely on free info you get from the internet. So overall, the trademark registration process and the application process really isn't all that different if we're talking about a word mark or a standard character mark versus a design mark like a logo. In fact, really, the process, every individual applicant and every trademark is going to go through, the process is going to be a little different for every application. But overall, the process, the general steps and process that the application goes through is more or less exactly the same, regardless of the type of trademark that we're dealing with. But there are a few kind of specifics that apply only to design marks or special form marks like logos. And so that's the stuff that we're going to focus on today, is some of those specific details that really only apply to logos. As I've discussed in my previous videos, the first step anytime we're talking about trademarks or getting a trademark registration, the first step is always going to be doing a clearance search. We want to make sure we search the USPTO database at the very least to make sure we've got a pretty decent chance at getting this trademark registered. Is it going to conflict with some other pending application or some trademark registration? Is there going to be some likelihood of confusion that might prevent our trademark from being registered? To do a search for a logo or a design, we're going to need to use the structured or free form search options available on TESS. And we're going to need to look through the design code manual to find the design codes that line up with our design in our logo or in our trademark. So let's pretend I have a logo, and let's say my logo is a cat playing the piano. That's my logo. For whatever reason, my logo contains the drawing of a cat playing a piano. So if I want to do a trademark search to see if there are other logos of cats playing pianos that might be too similar to mine, first I'm going to need to look up the design code for cats. We can see in the design code manual that animals fall under a certain design code class or category, which is category 3. And the design code for domestic cats, which is what my pretend logo has, is code 030104. So that's the design code for domestic cats. We're also going to need to find the design code for a piano. It looks like musical instruments fall under category 22, and the design code for pianos is 220101. So I can now plug in those two design codes into either the free form or the structured search and tell it to search for both design codes for cats and pianos. And that search is going to give me any designs, any registrations or pending applications that include both a domestic cat, and a piano. And then I can look through those results, see if any of those might be confusingly similar to mine, and assess if something might get in the way of my application and my trademark registration for my own logo. So that's the first difference when we're talking about logo versus just a standard character or word mark. The search is going to be a little different because we have to use these design codes. We've got that out of the way though, and now we can move on to the actual application itself. So on one of the first pages of the application, of course, we have to give a drawing of the mark. Tell the USPTO what is this trademark that we're looking to register. On this page of the application, we're going to select the special form or design mark option. This will let us upload an image of our design of our logo. A few particulars here: the image that you upload for your trademark drawing, it has to be a JPEG file format. It needs to be under 5 megabytes, I believe. And then the pixel count range should be between 250 and I think 944. That's the recommended pixel range for your image. So you want to make sure it meets those requirements. Otherwise, the USPTO system will say, this doesn't meet our requirements. You need to adjust it before we'll let you upload it. We also need to make sure that the drawing that we upload is going to match the drawing of the logo as we're actually going to use it. This is a big question that comes up when I'm working with clients and registering their trademarks for their logos. Often we might have different variations of our logo. Maybe we have one where there's a symbol or an icon and then our business name is next to it. Maybe we have one variation though where the symbol or the icon is above the name. So it's more of a vertical stack versus a horizontal image. Maybe we have some variations where it's just an icon. Maybe I don't use my business name in my logo all the time. Maybe it's just that cat and piano image. So we might have a bunch of different variations. Each variation of your logo is, for the most part, a separate, distinct trademark from all the others. And so they are all their own trademarks, and they would all theoretically need to be registered separately. So let's say I've got a vertical and a horizontal version of my logo. If I upload a drawing of the vertical version, that's what the USPTO is going to want to see that I'm actually using. I can't upload a horizontal logo and then later on show them that I'm actually using the vertical version. There are two different trademarks, so you need to make sure the one that you upload as your drawing is the version that you're actually using as a trademark. If our logo does contain some text, some literal element, some words like our business name, maybe a slogan or a tagline, we need to indicate the literal element of the logo on the application as well. We also have to indicate if we are going to claim color as a feature of the trademark. And this is another big kind of sticking point that people get confused about. When we register our trademark for our logo, that registration, that protection is specific to the design of the logo, and that can include color. So when would we want to include color and claim color as a feature of the mark? In my opinion, it's not often, and it's usually only after we've registered our logo without any kind of color claim. Again, it always kind of depends. Every person's situation is different. Every business situation is different. If it's one or the other, if this is your first time registering a trademark for your logo, I almost always say let's start by doing just no color claim. We want to protect your logo regardless of the colors that you use on it. If we do it without a claim of color, then there's no specific color there, and the way you use it can be whatever colors you want. Versus if we claim color, then that's the color that's specific to the trademark, and that's the color or colors we're gonna have to use. So, when in doubt, well, no, I take that back. When in doubt, talk to a lawyer. Outside of that though, when in doubt, I generally err towards not claiming color and doing just a black and white drawing of your logo. And if that's the case, if you're not going to claim color, then you need to provide as the drawing a black and white or grayscale drawing of your logo. Versus if we are claiming color, then we need to upload it with those colors that we're going to be claiming. And then finally, we're going to need to give a description of the drawing. This part, you guys, is sometimes difficult for me too. We have to describe what does our logo, what does our design consist of. Sometimes it's easy. Maybe it's, stylized text of, our business name or something. For mine, let's use my actual logo, not my cat playing the piano logo, but my actual 180 Lawco logo. Let's say I was going to register the trademark for this. The description would be something like, the mark consists of the words 180 Lawco with a partial circle or an incomplete circle around the 180. Something like that. If there are other elements, you want to describe those. You want to include a description of what other text is in there. And if you're claiming color, then you want to be specific in that description of, a blue cat playing a pink piano. Whatever it is, we need to type that in there. Don't get too hung up or stressed out about this. If your description isn't perfect, the examining attorney will adjust it or make suggestions for how to correct your description if it's not exactly how it needs to be. Just give kind of a general description of what your design consists of. And then moving on in the application, we're also going to have to provide the filing basis and the goods and services description. So what goods and services are we going to be using our trademark in connection with, and the filing basis, which for most of us is going to be either 1A current use or 1B intent to use basis. If you apply on a 1A current use basis, you're also going to have to provide a specimen or proof of your use of the trademark along with information about your date of first use. If you file on a 1B intent to use basis, you'll still have to provide that info, but you won't have to do it until later on in the process, about maybe a year and a half in the process after the examining attorney issues a notice of allowance. But in either event, either with the application or later on, you'll have to submit a specimen showing that you are using the trademark in commerce in connection with the goods or services that you identify on the application. And again, this is where it comes in that it's so important that the specimen, the trademark as it appears on the specimen, has to match the trademark as it appears in the drawing. So let's say you claimed color as a feature of the mark, and on the drawing your logo is red. On the specimen it's blue. Nope, those are different trademarks. That specimen's not going to be acceptable. It has to be the same color. If you did not claim color as a feature of the mark, then it can be whatever color you want it to be on the specimen. But again, it does have to still match if it's vertical versus horizontal, if it has the same literal element. It has to have the exact same design. It has to be the same design as what you submitted on the drawing on the application. If it doesn't, if your specimen, if the trademark as it appears on your specimen does not match with the trademark as you provided it in the application, the examining attorney is going to reject it, say, nope, you need to give us a substitute specimen. You need to show us you're using that actual trademark. But then we submit either the specimen if we're filing on a 1A basis, or we leave that out and save it for later if we're filing on a 1B. Then provide, a signature on the application, pay some fees, hit submit. And then from there, the process again is really the same as it is for a standard character mark or any other kind of trademark, with one small exception. So generally, and this is still true for design marks, current processing time with all trademark applications, we're not hearing anything back. No one's being assigned to your application. No one's really touching it for about 10 months right now, closer to about a year. And that's the same for applications for design marks, except you will, a few weeks after you submit the application, you should get some email notification from the USPTO that they've assigned design codes to your trademark. So someone behind the scenes is looking at your logo or your design, and they're assigning those appropriate design codes to it. There's not really a whole lot you need to do when you get that email. I like to just look, make sure the design codes are accurate. Like if the design code, if my cat playing a piano is my logo and the design code they assign is a dog playing a harmonica, I might, get in touch with the examining attorney and say, this doesn't seem right. But as long as the design codes line up with what's actually in your logo, there's not a whole lot you need to do about that. Outside of that though, just like all the other applications, you won't hear anything for about 10 months, probably closer to a year currently, until an examining attorney has been assigned to your application. Then they go through their whole process of evaluating it, making sure it's available, it won't conflict with any other registrations, then it gets published for opposition. And then if you did file on a 1B basis, then you get that notice of allowance. You have to submit a specimen. And then ultimately, if all goes well, the trademark is registered and you've got a beautiful trademark certificate and your beautiful logo is protected and secured. That's all for this episode, folks. If you learned a thing or two, go ahead and give me a thumbs up, and be sure to subscribe if you haven't already done so, and click that little bell so you get notified when I post a new video. And don't forget to check the description for more info and resources, including a link to download my free Brandish DIY trademark guide. You know, particularly when we're talking about trademark registration for logos, a lot of questions come up when we're dealing with logos and design marks. And thankfully, I did a whole video not too long ago where I responded to all of your trademark related questions. I will put it right here. I'll meet you guys over there if you want to learn more about trademarks. I'll see you over at that video. Thank you so much for watching. I'm Aiden Durham, and I'll see you next time. All right, Bird, you don't have to stay and talk about trademarks. You hate this, I'm sure. Okay. Bye, Bird. Thanks for hanging out with us.